Yeah, let us start off by defining bail. Bail is the temporary release of a suspect on production of a bond. Temporary release of a suspect on the production of a bond or a convict before the appeal process is completed. Bail is a constitutional issue. The 1999 Constitution of the Federal Republic of Nigeria provides that a suspect who has been arrested on allegation of having committed an offense must be charged to court within 24 hours, where a court of competent jurisdiction is located within a radius of 40 kilometers from the police station, and where a court is located within a radius of above 40 kilometers from the police station. The suspect must be charged to court within 40 court might consider reasonable. Are you still with me? Bail is subsumed in the constitutional provision, particularly section 36 sub 5, which presumes that every person who is facing trial or a suspect arrested is presumed innocent until proven guilty. Therefore, it is illegal and unconstitutional for a suspect to be arrested and detained for more than 48 hours by the police or other law enforcement agencies such as EFCC and so on and so forth, without bail or without charging the suspect to court within the stipulated time as provided by the Constitution. Apart from the constitutional provision, there are several other statutory provisions regulating bail. For instance, Section 27 of the Police Act empowers the police to grant bail to a suspect pending their investigation. Similarly, Part 19 of the Administration of Criminal Justice Law of Edo State 2018, particularly Section 158 to 188 of the law, makes general procedural provisions for bail, while Section 30 and Section 31 of the law, referred to as the judicial bail, is bail pending trial or bail pending appeal by a convict. However, both the administrative and judicial bail are guided by certain factors or principles that before a suspect is released on bail, the law enforcement agencies empowered by law to grant bail, and the courts have to take some of these factors into consideration. Some of them are the character of the suspect, the prevalence of seriousness of the offense in that particular community, the likelihood of committing some or same offense, the safety of the suspect. 4, 5 attempts to evade this trial. 6 attempts to influence, interfere with or intimidate witnesses and or interfere with the investigation of the case, or attempt to conceal or destroy evidence. Prejudice to the proper investigation of the case. Sections 1612 and 162 of the Administration of Criminal Justice Law outline some of these circumstances which the court may consider in the exercise of its discretion in granting bail. Aside the several statutory provisions regulating bail, there is also judicial pronouncement on the conditions to be considered by courts in granting or refusing bail to an applicant. And some of these are the nature of the offense and punishment prescribed, as you can find in the case of Acha against the state. 2, the nature, character, and quality of evidence against the defendant. The possibility of the defendant interfering with further investigation or prosecution of the case if granted bail. Detention for the protection of the defendant as referred to earlier on, and so on and so forth. Furthermore, a defendant who has been convicted by a trial court is entitled to bail pending the outcome of his appeal, provided it shows exceptional circumstances why bail should be granted. This is known as bail pending appeal. Both the trial and appellate court have powers to admit to bail a convict or a defendant who has been convicted of an offense and sentenced by the trial court, particularly where that such sentence has no option of a fine. But where the sentence has an option of a fine, the convict may be encouraged to pay the fine while he pursues his bail or his appeal. The intricacies as reflected in the topic. We are familiar with the popular cliché that is usually presented in some of these arresting agencies' offices, where we says bail is free. Well, we may not go into that. Some of these intricacies also have to do with the attitude of law enforcement officers, particularly the junior officers. It is for this reason that counsel are usually advised to seek audience with very senior officers who are likely to respect judicial notice, as it were, of the attitude or conduct of lawyers who appear in court. Take, for example, where the court forms an opinion that counsel who come to his court usually will assist or aid the client to jump bail. When such a counsel comes forward asking for bail, the court will not be disposed to granting bail. And again, you must show some respect to courts. You also remember one cardinal principle in the issue of bail is said that bail is at the discretion of the court. And when the court exercises such discretion, you can hardly question that exercise of discretion. That is appropriately when you appear before courts. Even the court of first instance, take for instance magistrate court up to the highest court in the land. Thank you very much.
Okay, my Lord, we are very, very grateful for the lecture. We are indeed grateful. Words alone cannot express our appreciation. Indeed, you have opened our eyes further on the concept of bail under the Nigerian law. Though before now, I must confess, I have limited knowledge when it comes to bail. But with your lecture today, I believe it will enable me, it has assisted me a lot to actually understand bail under the Nigerian law. My Lord, without wasting much time, we'll open the floor in the house for questions. Maybe the question will be limited. Like we said earlier on, listeners, ensure that your question revolves around the and please ensure.
Okay, my Lord, can you hear me?
I can hear you.
Bail in Nigeria is free. That citizens, when arrested, ought not to pay. I can hear you. Ought not to pay any money or give any money.
Hello, go on.
Or the court, as the case may be, before he or she is granted bail. But oftentimes we see or hear situation where people have to pay money even to the police, in order for them to be granted bail, even in court. Now, my question is, my Lord, those money, because we know very well that before a court grants a suspect bail or an accused bail, as the case may be, there are certain requirements the accused has to furnish or has to
even in court. Now, my question is, my Lord, those
Now, the
money,
question
because
is, and
we
one of
know
it is that the
very
accused
well
is
that
asked to
before a court
deposit money.
grants a suspect
Most
bail
times,
or an
they
actual
ask
an
the
accused as a
shorty
case
or
there
one or two
are certain
persons to even
requirements the
deposit the
accused
life
has to
sum.
furnish
Now, the question
or
is
has
that those
to pay
money
before
that
the court grants that
those
accused bail. Now, the
money that the
question is, and
accused
one
in
of it
question
is that
or
the
his
accused is asked to deposit
shorty, as
money.
the case may be,
Most times,
deposit
they ask the shorty
for in order
or
for him
one
to
or
get
two
bail.
shorties to
If
even deposit
after
the
the
life sum.
determination of
Now, the
that
question
case,
is that those
accused
money that
perhaps
those
is
money that the
condemned
accused in
or
question or
acquitted
his
by the court,
shorty as the case may
does
be
those
deposit
money does the court
for in
refund
order
those
for him to
money to
get
the
bail.
accused?
If after the determination of that case, that accused perhaps is
Yes, I can hear you.
condemned or acquitted by the court, does those money does the court refund those money to the accused?
Can you hear me now?
Yes, I can hear you.
Yes. Yeah, there's always the general misconception. When the court grants bail and fixes an amount of money by the shorty, that the shorty in terms of money, those monies, that amount is not paid, is not put on the ground. But sometimes a suspect or a defendant may be required to deposit an amount of money. It's just mere guarantee to ensure that such defendant faces his trial, or when he adjusts bail, that is when that amount of money will be forfeited to government. And there's usually a separate proceedings for shorty to show cause. That is when the suspect jumps bail, when the defendant jumps bail. But where the defendant faces his trial till the end, even when the money is deposited, is refunded, is given back to the suspect or the shorty. It's not forfeited to government. It's just a bond. It's a guarantee to ensure that the defendant will attend his trial. Or if it's at the police station or the any law enforcement agency, to ensure that the suspect will be found and then eventually charged to court. It's not for the agency, it is not for government. As long as such a defendant faces his trial to the end. Am I clear?
I get it.
I think I have a question.
I think I get your explanation. Thank you very much, my lord.
Yes.
Okay, you can
Okay, so anybody have that question for us, my lord?
Yes.
One after
My
another.
name is Philip Kibas,
I think
300 law level.
Okay, you can take it from
Your Lordship, I want to commend the way you tackle the issue of bail. And my eyes are really open and I've learned a lot. But there is this act of the police that is really bothering me. It is notorious that jail is free, but most often you see lawyers having problem with the police. When they go to bail their client, the police will be requesting for money. What if the lawyer doesn't want to pay the money and the police insist that he must pay and is not willing to pay? What is the next?
The police will be requesting for money.
Course of action for the lawyer. And I also have another question. My question is, I can hear your Lordship.
What is the name?
Can you hear me? Okay, are you through with the question? Hello?
Hello, my
Your Lordship, I can hear you.
Yes. You know, it is the general corruption that we all speak about. A suspect who has been arrested by the police should not pay one kobo to the police to get his temporary release. The police is not a trial court. The police cannot send a suspect to prison custody. Only the court can. Again, the attitude of our people. If when the police arrests a suspect or any law enforcement agency at that, the suspect makes up his mind that I will go through, I'm innocent, I will go through this investigation. without giving one cover to the police. And if we all maintain that attitude and take that stand, I'm sure the police, after a while, or any of these agencies, will learn to release persons without insisting on their paying any money. But again, there are procedures. I don't know if you are aware of the fundamental human rights procedure. The process is there available. And it is the reason why summons for bail, applications for bail, where is the agency refuses to grant bail or refuses to release a suspect, such a person can go through his lawyer, file an application to court, and the court will hear that application and grant bail to such a suspect. When the police refuses to grant bail, you file an application to court and ask for bail. And again, where the police unduly detains a person beyond the period stipulated by law, you can file an application under the fundamental human right asking for compensation for such illegal detention, unlawful detention. That is the remedy available to a citizen.
Okay. Thank you, Your Lordship, for the
Okay, thank you, Your Lordship. I think
Hello?
response. I really appreciate. Can Your Lordship
Hello?
hear me?
Hello?
Yes.
Hello? Can you hear me?
Your Lordship, I also have another question.
I can hear now, yes.
Go ahead. Your Lordship is listening to you.
Yes, go ahead.
Okay, Your Lordship, a case is before the High Court and the client is behind bars and his lawyer made an application before the High Court for bail, and since bail is discretional, the High Court judge refuses the bail. Is that the end of the application, or is the lawyer entitled to forward his bail application to other superior courts? That's my question, Your Lordship. Does bail application ends at the trial court, or can a lawyer further apply for bail in superior courts?
Yes, if you apply for bail at the trial court, take for instance the magistrate court, where the magistrate has jurisdiction to hear the matter, or the High Court, and the court of trial refuses bail. Yeah, so let me repeat myself. Yes, if a trial is going on either at the magistrate court, the trial refuses to grant bail to the defendant, such a defendant can apply to a higher court, either the High Court in the case of trial at the magistrate court, or the Court of Appeal in the case of trial at the High Court. And the appellate court will consider such an application and in appropriate case grant bail. But you must have good grounds or reason, for applying to the higher court for bail. You can make application to a higher court for bail.
I think Your Lordship have answered that question. Thank you, Your Lordship. We believe the person who has the question is satisfied with the question. Your Lordship have answered that question, and I believe the person who has the question is satisfied with the question.
So, yes, I'm very satisfied with
Yes,
Another question we are waiting.
Any other question?
Okay, it's like they are satisfied with your interpretation.
Thank you very much.
Okay, my Lord. Finally, I have one more question before we move on.
Yes, go ahead.
Okay, my Lord. My question is police. Now, when the police suspect, when of course when you go there to request for bail for that, police always ask pay money. I understand your lordship as actually don't just the discussion. But the question is, there was the former inspector general of police. I think the one before this one. There was a time he said those money that the police collect, they are called administrative fees. Many people collect. They can actually request money for such suspects because according to him, he was saying those money are being used to maintain the police station in terms of paying insurance, electricity fee, and all that. So the question I'm asking now, considering Section 27 of the Act that empowers the police to grant bail to a suspect, and they themselves requesting money. But what we are saying, is it legal for is it legal to give to pay such money to the police upon being arrested?
Yes. Can you hear me, Chief Judge or Chief Justice of the Student Court? Can you hear me?
Yes, sir. I can hear you, my lord.
Yes. I doubt it very much that you heard the former Inspector General of Police say that. No policeman can ever say a thing like that. I'm sure if you press them hard, they will deny that they said anything of such. And I'm sure you did not hear them say that. It will ache the ear for a policeman, no matter the rank or the level of a policeman, to say that suspects should pay money to take care of police station. Sure, you did not hear the Inspector General of Police well. He will not say that. No police officer will say that. The police is not expected to ask suspect one kobo. Even when they ask you to bring money to buy sheets of paper to make statements, those are illegal collections. It is illegal, it is unlawful, it is wrong. And if you can prove it by whatever means, such a policeman will be sanctioned, will be disciplined appropriately. So you are not expected to pay. It's like somebody coming to court and saying that the court is requesting money for administrative purposes. It is wrong. The court will never accept a request for money that cannot be receipted for. You hear me?
Yes, my lord.
As properly guided, my lord.
Yes, I don't think you heard the. Go back and conduct your research again. The Inspector General of Police did not say that. He cannot say that.
As properly guided, my lord.
We want to, my lord, on behalf of students, we want to really appreciate your time and your effort to educate us under the Nigerian law, considering that this has always been a recurrent issue for Nigerian considering the abuse of human rights in Nigeria. My lord,
yes, thank you very much. I would really have wished that we had opportunity to have a more robust discussion, and then a situation. I would have preferred a situation where we will really and properly interact, where I can really communicate, and then you ask questions. But unfortunately, the technology we are using will not allow us to achieve this purpose. I am looking forward to having a more involving discussion where more of your students will be around, particularly when the physical interaction will improve. Physical interaction, when it improves, if we have opportunity again, I would like to meet and we look at these issues again, either this or other issues. I'll be available to take them up with you. Thank you very much.
We'll ensure we do that.
Thank you. Thank you. Wish you the best. Thanks. Bye bye.
Thank you, my lord.
Thank you, my lord.